Labor Code Section 7 of Industrial Disputes Act says, it gives the meaning of labor code as the courts for adjudication of industrial disputes relating to any matter specified in second schedule and for performing other functions prescribed for them in act. Okay, any court which adjudicates industrial disputes relating to matters specified in second schedule, they are labor courts. Or there are other functions prescribed in industrial disputes act, the labor code can perform those functions also. Okay, so this was the meaning of labor code given in section 7 of industrial disputes act. The labor court is constituted by the appropriate government by putting notification in the official gazette. Now see the constitution or structure of labor code, how it's constituted. Section 7(1) empowers the government to establish one or more labor court in a state. Okay, the central government can establish the labor court in any state for matters for which it is the appropriate government. Now see about presiding officer. The government can appoint only one person as a presiding officer. Okay, only one person appointed by government. His qualifications are given in section 7(3). Whether he is or has been a judge of high court or district judge or additional district judge for more than 3 years, or judicial officer for more than 7 years, or labor court presiding officer under state act for more than 5 years, or deputy labor commissioner in center or joint commissioner in state for more than 7 years, and he also must have degree of law. Before joining as a presiding officer, he must resign from these posts. Or he may be a grade 3 Indian legal service officer for more than 3 years. If he has either of any of these qualifications, he can be a presiding officer. Functions of labor court, as we have seen in the definition, labor code adjudicates industrial disputes relating to matters specified in second schedule. So what are the matters specified in second schedule? In second schedule there are standing orders. Standing orders are terms and conditions or rules for the employment. They are the terms and conditions or rule related to the employment. Okay, if any employer passes any order under the standing order, okay, that matter can be adjudicated by the labor court if there is any industrial dispute on that order, or the matter can be about the application or interpretation of the standing orders, or it can be about the discharge or dismissal or restatement or grant of relief of, or there is any withdrawal of any customary concession or privilege, or to adjudicate about the illegality of strike or lockout, or anything other about strike or lockout, or it can adjudicate on matters, all matters other than specified in third schedule. Okay, the matters specified in third schedule. Okay, and all other matters which are not in third schedule, it can adjudicate in all matters which are not specified in the third schedule. Okay, all matters excluding the matters in third schedule. The labor court can perform other functions assigned under industrial disputes act, as we have seen in the definition, or any matter appearing to be connected to industrial dispute or relevant to it. Okay, if there is any industrial dispute which is being adjudicated by the labor court, and there is any matter which is connected to that industrial dispute, the labor court can adjudicate that matter also, or the matter is relevant to the industrial dispute, then also the labor court can adjudicate about that matter. So these were the functions. Now powers and procedure of labor court. There are three situations First is when labor court is trying industrial dispute. Another one is when labor court is trying offenses. And another one is when labor court is trying the rights given under special acts. Okay. In all the three situations, there are different procedures and powers. While trying industrial dispute, labor court has the same powers as the civil court. It follows the procedure of civil. It follows the code of civil procedure. What are the powers? It can compel attendance or examine on oath. It can compel the production of documents or material objects. It can issue commission for examination of witness or any other matter as may be prescribed. In addition, labor court has the right to appoint two assessors to advise or aid in proceeding. These assessors must be experts in the concerned matter. The labor court has the right to award incidental or secondary or additional cost, or has the right to award reinstatement or any other relief. While trying offences, the labor court has the same power as the court of first class magistrate. It follows and as nearly as possible summary procedure as provided under Criminal Procedure Code. While trying rights under special acts confer rights of litigants. Labor court can apply own procedure. So these were the powers and procedures under the three situations by the labor court. Withdrawal of case. When a case can be withdrawn from labor court, if the parties resolve the matter amicably before final order by labor court. Okay, before the labor court has made his final order, the parties have resolved the matter amicably, then the labor court can allow the withdrawal if sufficient grounds for such withdrawal. So this was withdrawal of case. Let's have a quick summary. Labor Code Section 7 meaning is given. Courts for adjudication of industrial disputes relating to any matter specified in second schedule and for performing other functions prescribed in the act. It is constituted by appropriate government by notification in official gazette. Its constitution, how it's constituted. Section 7(1) empowers government to establish one or more labor court in a state. Central government can establish in any state for matters for which it is appropriate government. The presiding officer is only one person appointed by the government. His qualifications may he is or has been judge of high court, district judge, additional district judge for 3 or more years, judicial officer for more than 7 years, labor court presiding officer under state act for more than 5 years, deputy labor commissioner in center or joint commissioner in state for more than 7 years. He must have a degree of law and he must resign before joining as a presiding officer, or he may be a grade 3 Indian legal service officer for more than 3 years. These were the qualifications to be the presiding officer. What are the functions of labor court? The labor court adjudicates industrial disputes relating to matters specified in second schedule. What are the matters specified in second schedule? In second schedule, there are standing orders. Standing orders are the terms and conditions or rules for employment. The employer may pass orders under standing orders. The labor court will adjudicate it. It comes under second schedule. Or the application or interpretation of the standing orders, the discharge, dismissal, state grant of relief, or the withdrawal of customary or concession privileges, or anything about strike or lockout, like its illegality or any other thing, and all other methods other than specified in third schedule. Okay, excluding third schedule, all other matters or any other function assigned under Industrial Dispute Act, or any matter which is connected to the industrial dispute or relevant to the industrial dispute. What are the powers and procedures? The powers under while trying industrial dispute are same as civil code. It has the same power as civil courts. The procedure followed is code of civil procedure. What are the powers? Compelling attendance, examine on oath, compelling production of documents and material objects, issue commission for examination of witness, or other matters as may be prescribed. In addition, labor court has the right to appoint two assessors to aid or advise in the proceeding. They must be experts in concerned matter. It has the right to award incidental cost, reinstatement, or other relief. While trying offences, the labor court has the same power as the court of first class magistrate. It follows as nearly as possible summary procedure as provided under CRPC, Criminal Procedure Code. While trying rights under special given under special act confers right to litigants, labor court can apply its own procedure. Withdrawal of cases, when the case can be withdrawn, when the parties resolve the matter amicably before the final order is given by the labor court. The labor court may allow the withdrawal if sufficient grounds for such withdrawal are there. So this was labor court. Next authority for settlement of industrial dispute will be industrial tribunal, which we will see in next video.